Louisiana v. Callais, or white people deliberately misunderstand racism again. Samuel Alito's intentional discrimination test is a natural next step for SCOTUS jurisprudence on racism because it's been delusional for decades. And before we dive into it, hi, I'm Rachel. I'm an attorney, and this is not legal advice, but it is going to be coming to you frequently and ever increasingly in long form. So if you'd like to support, like, subscribe, follow along on Substack, on YouTube, and consider signing up for a paid subscription on Substack because while none of this is ever paywalled, it is time consuming and it's very helpful to have financial support. Thank you to paid subscribers out there already. Let's get into it. The Supreme Court finished its multi-step destruction of the Voting Rights Act last week, functionally eliminating the ability to challenge racial gerrymanders aimed at diluting Black votes and disenfranchising Black voters. It was possible because of what we'd already let the court get away with, not just in election law, but in its broad definitions of discrimination. In the majority opinion in Louisiana v. Callais, Samuel Alito follows a predictable conservative Supreme Court playbook. First, he claims the decision absolutely does not eliminate Section 2 of the Voting Rights Act so that the New York Times can send a morning briefing that says, quote, the court's conservative justices said the decision upheld the Voting Rights Act of 1965, even as liberal justices accuse the court's majority of gutting that same law, end quote. Because why would the paper of record need to tell us what the truth is? It's really up to y'all. Second, Samuel Alito puts forth a definition of intentional discrimination that is nonsensical, rooted in a broader white American belief that a policy can only be racist if its proponents are yelling slurs as it passes, and decades of Supreme Court decisions that attempt to turn this belief into law. Callais takes this jurisprudence to new lows, but before explaining them, let's look at an example of the Rehnquist court developing what might be called I can't be racist, I have a Black friend case law about what constitutes unconstitutional racial discrimination. In 1978, Warren McCluskey, a Black man, was convicted of murdering a white police officer and sentenced to death by a Georgia jury. He appealed the conviction up to the Supreme Court, where his attorneys relied heavily on the Baldus study, a statistical analysis of Georgia death penalty cases in the 1970s. The Baldus study showed huge racial disparities at both charging and sentencing based on both the race of the defendant and the race of the victim. Quote, the death penalty was assessed in 22% of the cases involving Black defendants and white victims, 8% of the cases involving white defendants and white victims, 1% of the cases involving Black defendants and Black victims, and 3% of the cases involving white defendants and Black victims. Prosecutors sought the death penalty in 70% of the cases involving Black defendants and white victims, 32% of the cases involving white defendants and white victims, 15% of the cases involving Black defendants and Black victims, and 19% of the cases involving white defendants and Black victims, end quote. That's from the majority opinion. In a 5-4 decision, the court held that these statistics, which, as the dissent points out, demonstrate that, quote, it was more likely than not that the race of McCluskey's victim would determine whether or not he received a death sentence, end quote, were insufficient grounds to support a challenge under the 14th Amendment's Equal Protection Clause. The majority required McCluskey demonstrate, quote, purposeful discrimination, and that the decision makers in his case acted with discriminatory purpose, end quote. Alternatively, the court said McCluskey could prove that the Georgia legislature enacted or maintained the death penalty statute because of an anticipated racially discriminatory effect and that he had failed to do so. This idea of purposeful discrimination as individualized and accompanied by a note that says, this law works this way because we're racist and we're being racist on purpose as we pass this law, permeates the Supreme Court's Equal Protection Clause case law. It's a manifestation of a belief that permeates white America broadly, that racism is most often individualized and openly malicious. This belief allows white Americans to define what racism looks like in a way that is simple to identify and also enables widespread absolution. White people can assure themselves they are not racist so long as they have not personally participated in a hate crime. It's understandable why this belief is appealing. It also collapses when hit with an ounce of critical thinking. The Baldus study demonstrated widespread racism in the criminal legal system. There's no other way to explain the racial disparities that the study exposed. They controlled for other factors. Even if we give every prosecutor and every jury member the benefit of the doubt and assume that not a single one of them intended to punish people differently based on race, which is a pretty absurd amount of good faith to assume, given that Georgia's criminal courts had explicitly different penalties based on the race of perpetrators and victims for decades, the outcomes tell us that on some level, somehow the system must still be racist. It's racist even if no one expresses racial vitriol at sentencing. And so it must be possible for widespread racism to exist without that kind of open malice, and potentially without widespread individual intent. Knowing this, The court still created a framework that demands proof of open, individualized malice before people can seek redress. Quote, in its broadest form, McCleskey's claim of discrimination extends to every actor in the Georgia capital sentencing process, from the prosecutor who sought the death penalty and the jury that imposed the sentence to the state itself that enacted the capital punishment statute and allows it to remain in effect despite its allegedly discriminatory application, end quote. Well, yes, it doesn't mean that each of those actors was consciously trying to be racist, but that's literally what the Baldus study shows. That the application of the death penalty in Georgia, when controlled for everything else, was discriminatory based on race of perpetrator and victim. Allowing that system to stand implicates the process itself. The court's willful blindness to how racism actually works, here again, for the sake of argument, assuming a pretty absurd amount of good faith, is on stark display and expanding in Callais. Alito's opinion creates an impossible to overcome standard for proving intentional discrimination. Its construction is specific to drawing electoral maps, but its underlying logic is not. In Callais, the Roberts Court declares it impossible to prove intentional discrimination where there is any other possible justification for the shape of an electoral map. As he's wont to do, Samuel Alito says the quiet part out loud. His opinion acknowledges that, quote, race is often correlated with party preference, end quote, and then says that to prove intentional discrimination, quote, the plaintiffs must provide an analysis that controls for party affiliation. In other words, they must show that voters engage in racial bloc voting that cannot be explained by partisan affiliation, end quote. So in other words, Alito requires that a plaintiff challenging maps based on racial gerrymandering must overcome a presumption that the maps, even if they dilute Black voting power, were drawn to dilute Democratic voting power. 83% of Black voters are Democrats. These two things are functionally inseparable. Alito says if they cannot be separated, courts must assume that the motivation is not racist. He justifies this assumption mostly by implying that racism is over, and he justifies that implication McCleskey style by dismissing racial disparities as evidence of racism. Quote, discrimination that occurred some time ago, as well as present-day disparities that are characterized as the ongoing, scare quotes, effects of societal discrimination, are entitled to much less weight. If, as a result of this progress, it is hard to find pertinent evidence relating to intentional present-day voting discrimination, that is cause for celebration, end quote. Fuck Samuel Alito, man. It's not actually hard to find pertinent evidence relating to intentional present-day voting discrimination unless you say that one must presume the evidence is intentional voting discrimination based on partisan affiliation. Alito also declares that, quote, the focus of Section 2 must therefore be on current conditions, not on decades-old data relevant to decades-old problems, end quote. This is the legal equivalent of a doctor telling a diabetic that based on current blood sugar levels, they probably don't need their insulin pump anymore. The problems are centuries old, not decades old. Our country was built on and by chattel slavery. As the McCleskey dissent names, quote, it would be unrealistic to ignore the influence of history in assessing the plausible implications of McCleskey's evidence, end quote. The real decades-old problem is the Supreme Court's unwillingness to evaluate American racism honestly when crafting post-Civil Rights Act case law for fear that it will implicate our system too broadly. This fear has taken a false notion of what racism looks like and encoded it into law over and over to allow white Americans to ignore systemic complicity. While much of the conservative movement's evil work is coming to fruition now, it's possible because of decades spent painstakingly doing evil work that got less attention and the foundational racism present among white settlers that predates our country's founding. Undoing the harms of Callais, like undoing the many harms of Trump 2.0, will require understanding and then rejecting foundational and flawed American concepts of discrimination.